I'm Gary Feldman.
I'm Tamsin Kaplan.
So we're Davis Malm. We're two of the lawyers in the employment group. Welcome to our presentation on some new developments in employment law.
Well, I just got back from Rhode Island where I filled my prescription for medical marijuana. Not really. But the pharmacist gave it to me in a childproof baggie. And the directions on the baggie say, take medication, 2 hours later, eat everything in sight. But seriously, as you know, we have new legislation in Massachusetts, and very soon we're going to have dispensaries for medical marijuana. Typically, medical marijuana is used for pain, for situations where traditional medicine is not helpful, and sometimes for stress-related issues. Obviously, employers have concerns. Right now, many employers have either mandatory or random drug testing, including tests that would obviously pick up the use of marijuana. And some of you, depending on whether your companies use heavy equipment, whether people are driving motor vehicles in dangerous situations in their jobs, may be very strict about drug use among your employees. So medical marijuana is going to be an issue if somebody has a disability and they have to take medical marijuana. That's their prescribed treatment. Is that something that you have to accommodate? Do you have to allow them to use it? That's the question that is going to be facing employers. Okay, this is our first true-false, so get ready. Medical marijuana is coming to Massachusetts. Your employee comes in with a medical marijuana prescription and tells you he needs to smoke a joint every day at lunch. A whole joint. You are required to allow his use of medical marijuana as a reasonable accommodation under the ADA or state law. Is this true or false? What do you think? Okay, how many people think it's true? How many people think it's false? Oh, you guys are good. Did you know they were going to be this smart? Okay.
I think someone leaked them the slides.
So far, what we're seeing in other states is that there is not a requirement to accommodate the use of medical marijuana, even if it's use that is off premises. I mean, in the Massachusetts statute in particular, it says that an employer is not, it says, nothing in this law requires any accommodation of any on-site medical use of marijuana in any place of employment or of smoking medical marijuana in any public place. So it's explicit about on-site use of marijuana. However, it doesn't say anything about this other issue that I was just talking about, whether if somebody has, say, a positive drug test for marijuana, whether you can terminate them for that. And what we're seeing in other states is that this is a question that is a little bit, it's developing in the law. But in states where they have similar provisions that say you can't use it on site, for the most part, the courts are coming out in those states and saying that that means that you can terminate somebody if they test positive. So let's look at this one, having just given you a little clue. An employee with medical marijuana prescription is terminated for using medical marijuana at work or for testing positive for pot. The company will now be exposed to a huge award for terminating the employee in violation of the public policy of allowing medical marijuana. True? False. Okay. And we're saying likely false. And the reason we say likely false is because this law has not developed in Massachusetts yet. Obviously, we don't have any legal medical marijuana in Massachusetts yet. When we do, we again are expecting that because of that provision in the law that says you do not have to tolerate on-premises use during work time, we are expecting that, like other states, the courts are going to come out and say that you can terminate somebody for testing positive on a blood test.
The cases that have dealt with it so far, and there hasn't been a federal case in this jurisdiction, but the last time I looked, cases that had addressed it as a matter of federal ADA law. And since marijuana is still a Schedule I controlled substance under federal law, the cases all held, and there were 2 or 3 cases from the 8th Circuit and the 10th Circuit, case out west, that said as a matter of federal ADA law, there's no right, there's no reasonable accommodation that an employer is obligated to give, to provide for someone to smoke marijuana with or without a medical prescription. And so as a matter of federal law, there are no rights, and that's why it's likely false, because state law may be developing on a parallel track that may diverge as time moves forward, particularly in Colorado and in Washington, where, as you know, we're beyond medical marijuana, and marijuana is a legal substance, just like going to an just going to a liquor store.
Well, what I recommend, and I think Gary may differ in his advice, so I'm interested to hear what you say. What I'm recommending for Massachusetts employers is that they keep in mind whether, in fact, there is any bona fide business reason to require a clean blood test. If somebody has a disability, they're getting legitimate treatment from a doctor, including use of medical marijuana, and it's not affecting their performance, it's not affecting safety for them or for any coworkers, then I would say think long and hard before you terminate that person for a positive drug test showing marijuana.
The bottom line is there's no justification or no legal permission for using marijuana on the job as opposed to other prescriptions. But other prescriptions, particularly for people that are in safety sensitive positions, there are many people who are maybe on painkillers or on other legal prescriptions where their prescription would impair their ability to operate heavy equipment or perform in a safety sensitive position, and the employer is entitled to limit or reassign, but limit that work for that situation. So even with medical marijuana, it's clear you do not have an obligation under Massachusetts law to allow the use of medical marijuana on the job site during the working day. So the question that becomes trickier is on a conditional offer of employment, pre-employment drug screen, someone tests positive for the presence of marijuana, and they provide to you a medical prescription under when the dispensaries finally do open in Massachusetts, how to handle that.
So stick with us. Yes, Jeff?
I've got a question. If the federal law changes in any way, do you think that changes the whole, everything? If they decide, okay, it is medically, we allow medical marijuana?
Well, at this point, as Gary said, the law is developing on two tracks. And right now, under federal law, it's absolutely not required because it's not legal. Then there's state laws. There are some states now that are saying, well, it may be an accommodation under our disability laws. Some states then say, well, no, because it's trumped by federal law. Other states say, yes, under state law, this is a required accommodation. And so I think if federal law changes, then it's more likely that the states will easily go along with it and not allow you to terminate somebody for use of medical marijuana unless it affects their job, unless it's some kind of a legitimate job concern.
Yeah, it's not something that's necessarily dealing with, but I'm just curious, like, the federal law changes, states really aren't likely to say, no, it's still illegal in our state, even though the federal...
Probably not. One of the things that, we talk about states and it's all very general. One of the things to note is that most of these legalization of marijuana laws have come from referendums. So they're coming not from the legislators, they're coming from the public, from these grassroots efforts. So the amount of commitment to public policy in state government, I think, is not yet clear. But it does appear that that's the way things are going. I think I agree with you that for the most part it's going to get more and more lenient over time. But the fact is, if there's a safety concern or if use of marijuana affects somebody's ability to do their job, then they're not a qualified, it's not a qualified handicap. They're not a qualified person for their job. They can't do the essential functions of their job with or without an accommodation, and you'd have to let them go or require that they not use it. Does that make sense? Yeah.
For schools, if this changes, does this no longer become a drug-free zone and they can smoke it on campus?
I doubt if that's ever going to happen. Two things. Number one, I think we're mostly talking about using it, off premises, not on premises. I don't think that's ever going to happen. And in Massachusetts law, it specifically specifies that this does not mean you have to permit on premises use for employers. The other thing is that for the way that medical marijuana is actually prescribed, it's not necessarily smoking. There are inhalers, there are pills, so it can be taken like other medicines.
I think the most difficult, fast forward a few months, because eventually the Department of Public Health in the Commonwealth will get its act together and start licensing, and we're soon going to see the actual opening of real medical marijuana dispensaries. So fast forward 6 months from now, I think the most difficult question that you'll be facing and that we'll be on the receiving end of calls about are pre-employment drug screening tests. So a conditional offer of employment, typically many companies, many of you may require as part of a background check a drug screen. For all positions or only for safety for certain positions. So right now, if you do that and that test comes back positive for marijuana, I believe that the employer would be entitled to treat that as a failing drug test and rescind the conditional offer. Fast forward 6 months, medical marijuana is here. You perform that same pre-employment conditional drug test, and you've got a candidate who tests positive but produces a valid prescription from a licensed physician. That person's got a valid prescription for marijuana. Then that raises that's the hard question. So what is the employer's role and responsibility then in either a safety sensitive position or a non-safety sensitive position? You've got reasonable accommodation issues. Is that person to be treated just like anyone else who's suffering from a medical condition? Or will you be free to reject that person on the grounds of a positive drug test? I think, I think it's going to, that dividing line is going to be on the nature of the position. In a safety sensitive position, someone operating a truck driver on the road, someone operating heavy equipment, dangerous equipment, may lead to one set of answers as opposed to someone in a non-safety sensitive position.
But right now, you can have somebody come back with positive for Ritalin and that. So wouldn't the medical marijuana person have the ability to say, well, but you didn't reject so-and-so who I know takes Ritalin and produce their prescription because they have ADHD?
Mm-hmm.
Is there a fairness sort of?
Well, I think that
would be exactly the argument.
Yeah, that would be the argument that there is, like I said, there are a whole range of prescription medications that people lawfully take that could show up on a drug screen, some of which may have a tendency to impair their functioning on the job in certain positions, some of which may not. I'm not familiar enough with Ritalin to know in what way that would affect someone's ability to perform a safety-sensitive position.
Well, it wouldn't, but,
So that's why I said someone would treat.
You come back positive and somebody says, oh, you're positive, and you say, but I need this for.
But the next inquiry then is, does this affect the person's ability to do their job? Does it affect their safety or someone else's safety? And I think that's the analysis that we should be thinking about with medical marijuana as well. Because although right now at this moment you can just reject an applicant or terminate an employee for testing positive, I think down the road we're going to be dealing with this in a much more surgical way.
Baba yetu yetu liye mbinguni, yetu yetu amina. Baba yetu yetu liye jina lako litukuzwe.
Baba yetu yetu liye mbinguni, yetu yetu amina. Baba yetu yetu liye jina lako litukuzwe.
Tupe leo chakula chetu, tunachohitaji utusamehe makosa yetu. Kama nasi tulivyowasamehe waliotukosea, usitutie katika majaribu, lakini utuokoe na yule mwovu wa milele. Baba yetu yetu liye mbinguni, yetu yetu amina.
Baba yetu yetu liye jina lako litukuzwe.
Baba yetu yetu liye mbinguni, yetu yetu amina.
social media. I mean, we all know how prevalent it is and how much it's growing. Obviously, all of our employees are engaged in social media in some way or another, certainly those who are under, I don't know, 40. Of course, Gary is well over 40. And he's very
Thank you. I'm not, no anyone's accused me of being under 40 lately.
Okay, so let's get to the first true or false for social media. An employer is allowed to conduct a thorough internet search to get information about a job applicant, including from Facebook and other social media. Is that true? How many for false? Okay, that is right. At this time in Massachusetts, you absolutely can go on Facebook, go on other social media sites, and check out an applicant for a job. Even more so, an employer may require a job applicant to provide usernames and passcodes for Facebook and or other social media as a condition of employment. Do you think that's true? True? False? Interesting. It is actually true. Currently, under the law in Massachusetts, you can require an applicant for a job to give you their login information so that you can check them out. What about a current employee? An employer may require a current employee to provide usernames and passcodes for Facebook and or other social media as a condition of continuing employment. Okay, we can do this with an applicant. Can we do this with a current employee? True? We can? False, we can't. False, we can't. Okay, so these guys are so sharp. So, but what's Bob? Hey, Bob, how are you?
Hi, Tamsin, how are you? Bring the legal logic to that.
I think I will.
How an employee has less legal protection than an applicant.
Okay. Well, actually, the employee has more legal protection than the applicant. With the applicant, you can require login information. With the current employee, you cannot require login information. What is the difference and why? And it all goes back to the National Labor Relations Act. Yes, you have a question?
I was going to offer my guess.
Okay, go ahead. I'm sorry.
No consideration for the second one on what's written there.
Have you gone to law school? That's a very good guess, and it may be that that's a possible analysis. But the main issue here is the National Labor Relations Act, because under the National Labor Relations Act, all employees have a right to concerted activity and this is whether they're unionized or non-unionized, for the purposes of collective bargaining, if they're unionized, or if they're non-unionized, they have the right to concerted activity, which is activity among two or more employees, for the purpose of mutual aid or protection, meaning that they can communicate, employees have a right to communicate with each other about the terms and conditions of their employment. And the National Labor Relations Board now construes the breadth of terms and conditions of employment to be huge, to be very, very broad. So essentially any communication that relates to how people are treated at work, how people would like to be treated at work, how their boss spoke to them today, whether they're not happy with the benefits the company offers, any of these issues are concerted activity and people can communicate about them. That's what concerted activity is all about. So an applicant is not yet an employee, so they don't have these rights under the National Labor Relations Act. But once an employee, they're protected under the National Labor Relations Act, again, regardless of whether it's a union setting or a non-union setting. And therefore, we're not allowed to require them to allow us to view what they're saying on social media, potentially about the company and about their terms and conditions of employment. We can't ask for that as a condition of employment.
If you've asked for it when they were an applicant, and then you become an employee,
presumably you have that information.
but can you continue to access their accounts after they're an employee?
That's a very good question, and I'd say possibly you can, but you can't act on it.
Okay.
So what's the point?
Right.
Also, I would say that any intelligent employee and anybody you would want to hire would probably change their login information after they're hired.
Is it all states that allow us to ask for applicants' passcodes?
I'm so glad you asked that question because in your packet of materials you will see pending legislation in Massachusetts that already exists, I believe, in 28 states. There's already either proposed legislation or existing legislation in 28 states that makes it unlawful to require login information of applicants or employees. And the bill is in your materials. It says it shall be unlawful for an employer to require, request, suggest, or cause an employee or applicant to disclose a username, password, or other means for access or provide access through a username or password to a personal social media account or service, and it goes on from there. So there is a huge movement underway to make it just illegal by statute to access this information, to require access to this information as part of an applicant process or from your employees. This bill is pending in Massachusetts. My guess is that this will become law. This is a trend. And I think if you think about it, it makes sense. Social media is relatively new. We're all sort of feeling our way as to what makes sense. Currently, a huge majority of HR people do access social media to check people out. I mean, it's common practice. So it's interesting to see how legislatures around the company are reacting. They're reacting because people, interestingly, feel that their activities on social media are private.
So where this has come up over the last several years, I mean, you just saw the video on the boom on social media and how it's gotten into everyone, people's lives in so many ways. So many of you may have a social media policy in your employee handbook. And over the last 2 to 3 years, the National Labor Relations Board, through its Office of General Counsel, has gotten very aggressive in evaluating those kinds of policies for the kind of Section 7 rights, the concerted activity rights that Tamsin was talking about. So, and there's been a number of, national employers whose social media policies have been struck down and found to be an unfair labor practice, even though they're a non-union company, because of the kind of language that their social media policy contains.
Thank you. So if you check in your materials, there is a model social media policy there. And as Gary just mentioned, that came out of the National Labor Relations Board from their General Counsel's office. This is the recommended social media policy. So now switching to the issue of to what extent can you control employees' use of social media? Obviously, we're concerned about disparagement. We see situations where people leave the office, they may be disgruntled, and right away, they're getting on their blog or they're getting on their Facebook account or their whatever, tweeting, and they're talking about how bad their boss is or how crappily they're treated at work or the fact that there are cockroaches in the kitchen. So we are now looking at, again, concerted activity. Can employees work with each other for the aim of protecting each other in the workplace and mutually aiding each other in the workplace? They also have a right, of course, to unionize in the workplace. And so the National Labor Relations Board is looking at your right as an employer, they're balancing your right as an employer to protect your legitimate business needs, to protect your reputation, your goodwill, your relationships with your customers, your relationships with the public, your market share, against the rights of the employee to participate in concerted activity. So interestingly, I highly recommend to you, by the way, that you use this model policy because it's very, very tricky as to what's legal and what's not legal to prohibit in your employees' use of social media. Some examples of portions of policies that were considered to be illegal, prohibited under the National Labor Relations Act. A directive to employees to avoid harming the image and integrity of the company. Now, you'd think that you could tell employees that you can't harm the image or integrity of the company. But no, the National Labor Relations Board said you cannot do that. So if you look in the policy, what we focus on is you can't use vulgar language, you can't harass someone, you can't discriminate against someone, you can't use language that would be construed as violent in some way we have to be very specific about what it is people can't do, because they can complain about their job. They're allowed to. Prohibitions on employees posting online information about the employer that could be deemed material and non-public or confidential or proprietary. Again, you'd think that you could prohibit employees from posting confidential information. What you'll see in the policy is we have to more specifically define confidential information, because it may be that confidential information is information about what's going on behind closed doors in terms of treatment of employees. That they can talk about. Confidential information, that's your trade secrets, that's your business plans, that's your client information, your product information. That, of course, you can protect. So it's, as you can see, you have to really walk a fine line. Policy instructing employees that their online statements must be completely accurate and not misleading and not reveal non-public information on any public site, again, struck down, considered to be unlawful by the National Labor Relations Board. Provisions stating that offensive, this one I think is remarkable, offensive, demeaning, abusive, or inappropriate remarks are as out of place online as offline. That's a quote from a social media policy that the National Labor Relations Board ruled to be unlawful. Again, they are thinking, okay, in the broadest terms, could this chill concerted activity? Could this be construed by an employee as keeping them from talking about the terms and conditions of their employment in some way on social media? And if it can, then the National Labor Relations Board is going to say it's unlawful. So I definitely recommend that you take a look at the policy that's in there. It is coming directly from this government agency, and it's the way to go, because we have to walk a very fine line here.
Over the last couple of years, I've fielded a lot of calls from people like you, employers, who have found current employees, former employees posting online, whether Facebook, Twitter, on blogs, saying derogatory things about the business, their boss, customers, suppliers, and the initial reaction of the employer, of the company, is, I found so-and-so writing derogatory things about the company. Well, if they don't like the company, we're going to, and publicly posting that, we're going to get rid of them. So that's the initial expected reaction. So I would just advise, our advice to you is to take a deep breath, call your trusted advisor, call us, call your lawyer, because you have to be very careful in this area in terms of navigating through, in terms of what action an employer may be able to take against an employee who is posting online or making public comments that you may feel are derogatory, disrespectful, or negatively impacting the goodwill of your company. There are like I said, the NLRB has taken a very expansive view of a legitimate concerted activity in the area of social media. So maybe you've all been fortunate you haven't had that yet, but at some point you will, because I field a lot of calls on this issue.
But suppose, sort of in a corollary to the Donald Sterling and the LA Clippers issue, suppose I come across somebody making racist remarks, or I come across somebody who's saying, I don't want to have black customers or white customers or whatever, and other employees bring this to my attention.
There's no, and Tamsin will talk about, there's no licenses, there's no permission to engage in racially discriminatory communications. That is not protected concerted activity.
Right, and
So I
so
could fire them for that.
right. So specifically in your social media policy, you want to make sure that that you are focusing on what is illegal, what is not allowed, what is unacceptable, and that would be discriminatory, harassing, again, violent. And this is the stuff that we absolutely need to make unacceptable and act on it and be very clear about our policies on it. Okay. Shall we move on?
Yeah. Okay, so we're switching from medical marijuana and social media to the FMLA, everyone's favorite topic. I'm going to talk a little bit about the military family leave provisions. These amendments to the FMLA regulations have been in effect now for about a year. They came into effect in March of 2013. The regulations for military leave and caregiver under the FMLA are I would say they're very complex. They're detailed, and there are a lot of traps for the unwary in there. So I'm just going to pick out a few. I could do a whole day or a half a day presentation just on these amendments to the regulations alone, but I'm just gonna hit a couple of high points for you and then move along. But the overriding message is that these regulations are quite complex, and there may be some hidden rights or hidden obligations that you may not be aware of. So we'll start off. You have an employee who requests FMLA leave to arrange for the transfer to a hospice care facility and to work with the hospice staff for the mother of the employee's son. So your employee comes to you, says, I want to take FMLA leave so I can take care of my son's mother and arrange for her hospice care and medical treatment. My son, I'm the employee, my son is serving in the Navy, not in a war theater of conflict, but is on a deployment sailing the warm seas of the Mediterranean. But his mother needs medical treatment and care, and I'm coming to you and I'm going to say, I want to take FMLA leave. So you are required to provide this as unpaid leave. Obviously, by the way I've presented that, the answer to that is true. Under the military family leave provisions, there are two classifications of additional leave that were provided for the benefit of active service people and veterans as well. And one of them is what's called you've got the qualifying exigency leaves, and I'll talk about that, as well as military caregiver leave. So that's when an employee comes to you and says, I want to take a leave to give care or care for a qualified military person. So you got two groups of leaves that are encompassed under the FMLA: exigency leaves on behalf of someone serving and someone deployed under active orders, as well as caregiver leaves. So this one I took, and this is actually one of the exigency leaves that's identified in the regulations to care for a covered military person's family. So it doesn't have, notice that your employee is not asking for leave to take care of his or her mother. There's not a direct familial relationship between your employee in this scenario and the person requiring the hospice care, but that person requiring the hospice care or the medical treatment is the mother of an active military member deployed on orders. So that scenario, under these regulations, your employee has the right to take up to 12 weeks of unpaid FMLA leave. Some of the other qualifying exigencies, again, this is in the category of leave, FMLA leave for exigency circumstances for covered military members, would be to make arrangements in a military member's short notice deployment, where a military member is deploying within 7 days or less. And remember, the military person in this scenario is not your employee. Your employee is either the parent, son, daughter, or next of kin of the military member. So the person asking for leave is your employee. The person in the military serving is not your employee. So if I've got a parent or I've got a child who's gotten exigency short notice deployment on 7 days or less notice, I can come to you and ask for and you'd be obligated to give me FMLA leave. Same for attending military events and related activities such as official ceremonies, programs, informational briefings, or family support or assistance programs. Again, all relating to the military member's deployment. So again, I'm your employee, then I'm in a next of kin, I'm in a familiar relationship with the military member, I would have the right to FMLA leave. To obtain and arrange for certain child care and related activities that arise from the military member's covered active duty, including arranging for alternate date care, helping with the children. And here the employee taking the FMLA exigency leave does not need to be related to the military member's child. So I'm your employee, I'm in a familiar relationship with a military member. I don't have to be related to that military member's child, but if I'm the parent, son or daughter or next of kin of the military member, and there's a need to arrange for child care as an exigency for a military member who's deployed, that comes under the FMLA leave. This example specifically is addressed in the regulations for exigency leave relating to the covered military member's duty related to care of the military member's parent who is incapable of self-care, such as arranging for hospice care, alternate care. Again, I don't need, the regs say that your employee does not need to be in a parental relationship with that parent who needs the custodial care. That person has to be a parent of the military member. If I'm your employee and I'm in a relationship with that military member, I get leave. And there's additional exigency leaves, counseling sessions, financial legal arrangements, spend time with a military member who's got taking a temporary rest and recuperation leave during a deployment, and then certain post-deployment activities. So that one is true. Another one under the military leave FMLA amendments. So your company has 2 employees who are siblings. Your 2 employees' siblings have a 3rd sibling who is currently a member of the armed forces. Both employees, now in the exigency leave scenario, you're up to the FMLA, you're up to 12 weeks. So your 2 employees who are siblings have a 3rd sibling who's currently deployed. The employees ask for up to 26 weeks of leave to care for their service member sibling who sustained a disabling injury in the line of duty. Both of your employees, the 2 siblings, both of them are entitled to the leave, true or false? Fast forward, the answer is true and false. It depends. So the regulations provide for next of kin notification. If in his or her military papers, the service member has identified someone who's next of kin, and it could be someone in a more distant relationship than the siblings, the regs speak of a cousin, then if there's been a next of kin designation by the military member, then that's the next of kin person is the person who's entitled to the FMLA leave to care for a disabled or an injured military member. However, if the military member has not designated a next of kin, then all family members with the same level of relationship to the service member are considered the service member's next of kin and may take FMLA leave to provide care to the service member. So in the scenario I gave you, if your 2 employees who are siblings have a 3rd sibling who suffered a disabling injury during active duty and there's been no designation of next of kin, those 2 siblings are in the same relationship to the service member. They are each entitled to the FMLA leave. Under this aspect of the military leave amendments, it's not 12 weeks of leave we're talking about. They're entitled to up to 26 weeks of leave in a 12-month period, and it's not the same 12-month measuring period that you would typically be using for your other, for that employee's annual leave. So it really starts from the time of the caregiving responsibilities for the military member. One other wrinkle to this is that although the amount of leave for military caregiver is increased to 26 weeks, that under the regulations is the total amount of protected FMLA leave that your employee may take in a 12-month calendar period. So if that employee has already in that 12-month calendar period taken, say, 10 weeks for his or her own FMLA leave, they would have available as caregiver for a military member an additional 16 weeks of leave available. But you could be faced with a scenario where there's no next of kin designation and you've got siblings working for you. They would each be equally entitled to take up to 26 weeks of leave to provide care for a covered service member.
The 26 weeks, it doesn't have to be concomitant or something? Like
Well-
one can do their 26 and the other can do their 26?
That's, and I don't know the answer to that. I was thinking about that, whether they can take that leave concurrent. And I think that goes to the issue of how much care needs to be given. It would be, I think they would have to, if they were going to both say, we're going to take our 26 weeks concurrently, then I think the employer, and I don't know specifically, Carol, under the regulations, whether the regulations address that or whether there would have to be a demonstration of the need for two people as opposed to alternating days or alternating shifts. But they would each be, I mean, it's clear that under the regulations, if there's no next of kin designation as the employer, you could not say, all right, well, you, sibling A, you can take care of your brother, and you, sibling B, you work. They each have equal rights unless there's been a next of kin designation.
Well, it is totally appropriate to ask for medical certification. And so you would be looking for information from the doctor of the injured person to find out if, in fact, both siblings are required to be out of work at the same time. Shall we go on
Yes.
to the Wage Act?
Wage Act, okay. Any other questions about the military caregiver exigency regulations?
Just a quick question.
Sure.
The intermittent leave provision that FMLA has, does it also apply in
Yes.
military? It does.
Yes. Wage Act issues. The Massachusetts Wage Act, fraught with danger for employers. Wage Act provides if there's a violation of even a de minimis amount, you're looking at treble damages automatically now. You're looking at attorney's fees, and you're looking at potential retaliation claims. There was a recent decision report in Massachusetts which led to a verdict and judgment in favor of an employee of over almost $500,000 on a Wage Act retaliation claim, where the differential in the Wage Act, what the employee was claiming, amounted to about a 50-cent per hour discrepancy in the hourly wage and the hourly rate. And the employee apparently made a very modest demand to get the matter resolved. The employee ended up being terminated. The employee ended up bringing a retaliation claim. So the 50-cent, the differential in the wage payment between what was found to be due the employee versus what the employer paid was very small, amounted to just a couple of $1,000s. But because the employee was then terminated and successfully claimed retaliation, was able to get back wages, which were then trebled, and added attorney's fees. So you had basically a dispute over 50 cents or 50 cents an hour turned into a $500,000, close to about a $450,000, $475,000 judgment against the employer under the Wage Act. So, caution everyone here, you don't want to run into any trouble with the Wage Act because the penalties against the employer are significant. So where do we see a lot of wage? We don't see many Wage Act disputes like that where there's a disagreement as to what the agreement was to be for the compensation. We see it in terms of misclassification issues. Employer classifies a worker as an independent contractor. Turns out the person should have been properly classified as an employee. They weren't paid minimum wage. They weren't paid overtime because they were treated as an independent contractor. That can lead to a Wage Act issue. Deductions, chargebacks to the employee either during or most frequently at the end of employment can lead to Wage Act violations. So here, your company provides your employees with a laptop computer and a mobile device. The company is permitted to deduct the current fair market value of the equipment from the employee's last paycheck if the equipment is not returned or is returned damaged, true or false. How many of you think you can deduct the value of the equipment when the employee who either quits or is terminated and runs off with your laptop and your mobile phone? No one thinks you can do that. Okay, you're all right, you cannot do that. That would be a violation of the Wage Act. You are absolutely prohibited from, even with the agreement of the employee, of entering into any special contract that would deduct or withhold earned wages. You may only deduct pursuant to a valid attachment, that's a court order, a valid assignment, or what's called a valid set-off. We'll talk about what a valid set-off is. So your company is a retail store, and you have a policy that employees may purchase items on credit at cost, and then deduct the amounts from the employee's paycheck on a weekly or by paycheck pay period basis. Comes to the end of the employee's term with you, and there's still amounts due on the employee's purchases from the company. You have a written signed agreement that provides for the recovery from the final paycheck. Is this a permitted practice, true or false? Everyone think this is a permitted practice? Yeah, that is true. That is a permitted practice as long as you have, it's just like a loan to or an advance from an employer to the employee. As long as you have a written agreement that's got a stated amount signed by the employee, you're entitled to make that deduction from the final paycheck to either recover the balance of a loan or an advancement that the company made to the employee, or to recover the value of goods that the company sold or permitted the employee to purchase. The difference between this and the previous slide was this is a liquidated set amount. It's not subject to the discretion of the employer in determining what the value is. So the previous slide I told you is that you gave the employee at the beginning of their employment a laptop and a mobile phone, a mobile device. Say 2 years later, the employment ends, the employee runs off with your equipment or returns it in a damaged state. You make the determination, okay, the current fair market value of that device and that computer is X. That's an arbitrary, well, it's not necessarily arbitrary, but that's a unilateral determination by the employer. It's not liquidated, it's not a liquidated amount. It's not determined by a court of law, even though the employee has signed an agreement at the outset of the employment saying, if I don't return the equipment or return it damaged, you're entitled to charge me for your determination of what the fair market value of that equipment is at that time. That is not a permitted practice, and that would be a violation of the Wage Act. The difference between that and an advance or a loan to the employee or the sale of goods to the employee is that you have a written agreement, and then you have a sum certain that does not need to be judicially arbitrated or subject to discretion of anyone at the time. So there was within the last 6 to 12 months, the SJC in Massachusetts had a case, a trucking company who had a policy that if any of its drivers, I think it was a waste delivery, a garbage pickup company, if any of the drivers damaged any property, they had the option of either being subjected to disciplinary action, warnings, performance ratings, even termination, or paying back to the employer the damage in the amount determined by the employer. And the employee had the option either take the disciplinary action or take the set off on the payment terms. And the SJC concluded that was that was a violation of the Wage Act because it was the employer alone determining what the value of the damage was, and it wasn't subject to a judicial determination. So Wage Act issues. Yes?
We have a laptop agreement, but the employee is paying every week towards the laptop. So when they leave, it's agreed that they can either we pay them the value for what they put in, or they can pay us the remaining value. Is that okay?
Yes, okay. Because you've got a set amount, and that's an addition. That's similar to an advancement or selling of goods. You've stated it. Where the case where the SJC came down and the waste haul company was that you've got the employer making a decision unilaterally, A, whether or not the driver was at fault. So they only apply this when they determined that the driver was at fault, and then B, making the unilateral determination as to what the value of the damage was.
They didn't use their insurance?
What's that?
Can they use their insurance?
Well, the court said there's got to be, in that situation, there's got to be a judicial determination. So the bottom line was the employer cannot take the deduction, charge the employee as against their wages. If the employee was negligent, was at fault, caused the accident, they could go to court, sue them, or subrogate, have the insurance company sue them, and then establish their fault and the value. But the employer could not, on its own, without any means of redress for the employee, do that by way and then deduct that from wages. The SJ in Massachusetts, as in most states, wages are held to be sacrosanct, and it's very limited situations in which an employer can interfere with the payment of wages, particularly on a final paycheck.
So if someone goes to, so the only thing you can really do with an employee, other than go to court, is to do a disciplinary action with them, it sounds like, if they damage a property of the company?
You could do that because you're not interfering with their wages.
Right.
So if an employee, yes, you have a driver or equipment operator, there's an accident, damage to the equipment, the company's entitled to investigate and determine not if that employee was at fault. Maybe he or she was impaired at the time, wasn't following safety regulations, caused damage. That's certainly a matter of appropriate disciplinary action, but you can't go into their paycheck and make the company whole by taking away from their wages.
Can I just add to that? I'm sorry.
Go ahead.
Adam, that's a really good point. And whenever we deal with Wage Act issues, I always tell my clients, no matter what, you have to pay people for the time they worked. So say, for example, completely other issue, and another totally different issue that arises under the Wage Act, somebody is working extra hours without your permission, even though you have a policy that they need explicit advance permission to work extra hours. It's a non-exempt person. Do you have to pay them overtime? Yes, you have to pay them for every minute that they worked. Can you discipline them because they violated a policy because they did that work without your permission? Yes. Can you terminate them for that? Yes, but you have to pay them.
Gotcha. Thank you.
What about the use of a corporate credit card where the employee gets reimbursed personally and then is responsible for paying the corporate card back, and there's no pre-existing policy in place that it can be withdrawn?
If there's no pre-existing policy, signed agreement by the employee, I haven't looked at that, I would say no. The only situations in which the courts have found that it's a valid set-off would be where there's a signed agreement by the employee saying any balance due at the time of my employment ends, you may take from my paycheck. Signed by the employee. So going back to this example, one last Wage Act issue. So here you've got the employee purchased items on credit at cost from you, comes to the end of the employment, there's still an amount due. You've got a written agreement that you may deduct any such amounts from the employee's final paycheck. Now you have the situation, if by making that deduction and balancing out that debit account, can you do that if the deduction reduces the amount to be paid to the employee in their final paycheck below minimum wage for the hours worked? Anyone think that you can do that? You can take the deduction, even though it'll result in a final paycheck that'll result in a payment of wages less than the minimum wage for the hours worked? Unclear. Trick question. Such a set-off is valid under the FLSA, which is the federal law. So under the FLSA, where you've got a valid set-off, a signed agreement by the employee allowing you to make such deductions from the final paycheck, you can do that even though it reduces the net amount to the employee below minimum wage. However, because of Evie's hard work, we know that in Massachusetts, the Attorney General's office, which is the enforcement office for Wage Act violations, have not yet issued an opinion under Massachusetts wage and hour law, following up on that court decision I told you about with the waste hauling company. And the last information we have from the Attorney General has issued a written guidance on the Wage Act. So last we heard they are reviewing that and updating that to look at how the SJC's language in the camera decision would affect the ability of the employer to make the full deduction, even though it results in a less than minimum wage payment to the employee. So stay tuned.
Okay, switching to investigations. You get a complaint from an employee. It might be just an informal complaint, nothing formal, nothing in writing, that leads you to the conclusion that there may have been some unlawful sexual harassment, say in the workplace. What do? You are immediately required to respond, and the response must be prompt, and the response must include an investigation of the allegations. There should be some temporary remedial measures put in place so that the alleged perpetrator and the alleged victim are comfortable in the work environment. Sometimes it makes sense to put the alleged perpetrator on a paid administrative leave. Sometimes it makes sense for there to be some kind of a separation physically in the workplace. One thing that I see employers doing a lot in this situation is saying, hey, you two get together in a conference room and let's all chat about this. We don't do that because the nature of that kind of an allegation is that there's an unlevel playing field and that there's somebody who is feeling harassed, intimidated, uncomfortable with the other individual. So what does that investigation entail? You need to have a neutral investigator. All of the facts need to be investigated. We do this with interviews of everyone who's involved or who might have had some observations that would be helpful in determining what really happened. Oftentimes it's difficult to do this with an in-house investigator because you're the HR person, you interact with these people every day, you may have some preconceived ideas. Also, let's be honest, as the HR person, you may tend to view this more favorably to the employer, i.e., you may want to make sure that there's no liability. In Massachusetts, if a manager or supervisor is responsible for unlawful discrimination or harassment, the employer is automatically liable, automatically on the hook. So oftentimes, depending on the situation, you might bring in an independent investigator. Regardless of whether you do the investigation with an in-house person or with an investigator from the outside, the process has to be squeaky clean, because should there be some discipline or termination that arises at the end of this investigative process, you want to make sure that you're not going to be liable because something went wrong in the investigation. So say, for example, someone complains about sexual harassment. You decide that there was no sexual harassment and that in order to address the situation, you're going to move the employee who complained to a different workstation or to a different location. If that employee perceives that that's a less desirable location, they can allege retaliation. I made a legitimate good faith claim, I engaged in protected activity under the statute, and you adversely affected my employment. You took some kind of adverse action against me. Flip side, you may have problems if you are hasty and terminate somebody who is an alleged perpetrator who feels that they were innocent. So very tricky. What we do when we interview witnesses is we make sure that they understand that their participation in the investigation is protected. They cannot be retaliated against for participating in the investigation. And frequently until recently, we were advising employers that in the course of the investigation, you should require that all employees interviewed maintain complete confidentiality. Okay, now why has that consistently and traditionally been our advice? Any ideas, Misty?
To just protect everyone who's involved.
Sure, to protect everyone who's involved, to not have the matter get worse. I mean, sometimes if there are a lot of rumors in the workplace, the person who complained may feel vilified, marginalized. The person who was complained about, similarly, may feel that they're being treated unfairly. However, the NLRB, our favorite National Labor Relations Board, came out in a recent decision called Banner and said that no, you cannot across the board advise or instruct people who are your witnesses that they must keep the substance of the conversation, the substance of the interview confidential. You can tell the way I feel about this. However, there's a way around it, because this case laid out findings that you can make in advance of the investigation or in the advance of particular witness interviews that will allow you to give the instruction of complete confidentiality. And my opinion is that you can always make these findings, but you just have to go through the motions. You or your independent investigator have to make sure to go through go through this process of determining that one or more of these risks exists, document it, and therefore justify this confidentiality instruction. So you have to find, by the way, everything I'm referring to are in the email alerts that are in your materials. Gary and I, on a regular basis, do these email alerts to all of you and our other clients when new issues arise. So over the last couple years, we've done a fair amount of the material that we're covering today. Okay, so you have to find that there's a need for confidentiality to protect a witness, that there is a need for confidentiality because of a likelihood that evidence will be destroyed if you don't maintain confidentiality, that there is a threat that testimony from a witness might be fabricated if people have advance notice and they know what's going on and they're hearing what you're talking to other witnesses about, or 4, there's a need to prevent a cover-up. Now, I mean, it seems to me these are exactly the reasons why we always instructed our witnesses that confidentiality is necessary. But now we have to make sure that we make a finding, and I recommend that you document it, put it in your investigation file, so that you can then instruct everybody about confidentiality. Now, just a few words of advice about investigations. I recently concluded a 5-month investigation, and I talked to 110 witnesses. It was a huge investigation. Some people in this room helped me with it. And one of the key things is extremely careful either note-taking or taping of conversations. I do not like taping. I think that makes people uncomfortable. You have to have their consent in Massachusetts, of course, to tape them. I suggest instead you sit there with your laptop and take very good, thorough notes. Or if it's a key witness and you want to maintain eye contact and you want to be 100% focused on the witness, have a second person in the room with you, an HR assistant, or in our case, it was me and one of our other lawyers here, taking notes. You want to be sure to keep extremely careful documentation of your investigation. Again, neutrality is key. At the end of the investigation, both the alleged perpetrator and the alleged victim have to be informed of the results of the investigation. I recommend that there is always a report that goes in the investigation file. And of course, prompt remedial action is absolutely required by law if there is a finding that there has been some unlawful conduct. Final word of advice, and this is the most important thing I will tell you if you're ever doing an internal investigation as an employer, never find that there's been sexual harassment. Now, what do I mean by that? What I mean is, never in your findings do you need to say, we have concluded that as a matter of law, sexual harassment has occurred, because that would be an admission and you are automatically going to be liable if you're the employer of the supervisor who you just concluded broke the law. So what we say is, we have concluded that there's been a violation of our policies. Same thing, just be really careful what words you use when you're making conclusions in your report. If you've concluded that there's a violation of your policy and you've concluded that appropriate remedial measures require possibly termination of the person who caused this problem, that's fine. But I just advise you to be careful with the language you use. You don't want to put something in writing that is going to come back and bite you. Chris.
Following up on that point, a couple of days ago I mediated one of these cases. It was a sexual harassment case. And the HR department's file was completely useless because they may have orally received information, but the documentation was just not there. And Employees Council had a field day because people involved in the investigation from management's side, some were no longer at the company, some hadn't written things down. So the documentation is crucial.
Thank you. Chris is a wonderful mediator. I've mediated many cases with him. He's very talented. And he gets to see both sides of all these cases and what, 90-something% of the time settle the cases. So he has tremendous insights from the perspective of a neutral.
And nobody knows what really happens. It's perception. And if the file is thin, and if the only people involved in the investigation are supervisors or direct supervisors or best friends of, it's just not good for management.
When I know that oftentimes it's expensive to bring in an outside investigator, and you're not going to do it for every case, but I would certainly suggest that you seriously consider bringing in an outside investigator when the person against whom the allegations are being made is a high-level person in your company, because it is very difficult for an HR director or an in-house person to do a fair, neutral, open-minded, impartial investigation of their boss or of the COO or the CEO of the company or the executive director of the company. So just keep that in mind.
And keep in mind, not that it would change your course of action, but typically that investigator's file is not treated as it's not privileged, is not treated as attorney-client.
Right.
So it's not an attorney-client file. So if the matter moves from an internal investigation to a judicial proceeding, whether at the MCAD or in state or federal court, that investigation file and everything in it will likely be subject to discovery.
And your investigator will be a witness.
Right. So where, when that situation comes up for a regular client, and if I'm asked to investigate, one of the first questions I would ask is, okay, well, if this goes into litigation and we're your regular outside litigation counsel and we do the investigation, I wouldn't be able to do both. I wouldn't be able to investigate the matter, and then if the matter were to go into litigation, I wouldn't be able to be your outside litigation counsel. And so you don't have that particular issue if you're conducting an investigation in-house or internally, but just keep in mind that your investigation file is subject to discovery if it results in litigation.
And you're not going to use your lawyer to be your investigator. Your lawyer will help you find another person, an appropriate person. Oftentimes another lawyer from another law firm. That's oftentimes how I get pulled into investigations, is a lawyer from another firm actually brings me in to investigate in a workplace that is his clients. His or her clients. Okay, so next question. Moving on to another subject. Is an employer permitted to have policies governing personal relationships in the workplace? I was just talking to somebody down there about that earlier this morning. So can you tell your employees, you can't have a romantic or intimate relationship with your boss, or you can't work in the same department with someone from your family or your spouse? Is an employer permitted to have an employer is, this is true, false, an employer is permitted to do this, true? Absolutely true. One of the issues, obviously, that arises in a workplace is potential liability from romantic relationships that arise, particularly if it's between somebody who's a supervisor and somebody who's a supervisee, or any situation where one person has decision-making authority over the other in some way, giving them assignments, giving them evaluations, determining their wages, directing them in some way in the workplace. And the reason that this can really cause damage is because it not only is a workplace morale issue, it also is, again, a liability issue. So say there's a relationship that arises in the workplace, and at some point it becomes non-consensual. That could give rise to a sexual harassment claim. Say there's a perception by other people in the workplace that this relationship is going on, and as a result, a coworker is being treated in a preferential way. There's favoritism because of this perceived relationship. That person can bring a claim. There was just a recent case in Massachusetts where a person felt that they were being treated less favorably because of an intimate relationship that was going on or perceived to be going on between a coworker and a manager. And in fact, they found that that was sexual harassment because it was conduct of a sexual nature that was unwelcome and negatively impacting this observer, this third party. So we want to be very careful. And of course, there's the morale issue too, which is it can cause a lot of negative feeling, it can cause discomfort, jealousies can arise, and there can be perceptions of favoritism or perceptions of retaliation, even if they don't exist. Yes?
So what if it's too late and they're already having a relationship? Do you have them sign something? What do you do?
Well, everybody has a different take on this, but in fact, in your materials, you will find something that we call a love contract. So let's move on to this, and then I'll go back a little bit. Thank you, Amy. An employer may require employees who are romantically involved to sign a contract affirming that the relationship is consensual, releasing the employer from liability, and indemnifying the employer. Can you do that? Crazy as it seems, yes. And I've got 2 different love contracts in your materials. One of them is more laid back, and it just states that we're doing this, we know we're doing this, we know that there may be some liability, and we understand that we have to behave ourselves, no public displays of affection, no favoritism, etc. And then there's another one that actually includes, hi Linda, there's another one that actually includes indemnification language, release language. Personally, I think that's completely over the top. But it depends on your workplace environment, your culture, what's appropriate, under your circumstances. Going back to the policies, you'll see different examples of policies in your materials. The important thing, in my opinion, is to convey to people what your expectations are as an employer. So should one of these relationships evolve in the workplace, or should it already exist in the workplace, I prefer a policy where we talk about how this can be problematic, both from morale and from a legal point of view, so that people understand that this can give rise to problems. And we also require that the supervisor in the relationship make the relationship known to their boss or to HR, so that the company has this information, it's talked about with the involved parties, and there can be an opportunity to address the situation. Many times the best way to address the situation is to move one of the parties, if it's at all possible, for there to be a transfer, for there to be a relocation, so that you don't have a situation where 2 people are involved in a romantic relationship where, again, one has some decision-making authority relative to the terms and conditions of the other one's employment.
I would add that presents a very difficult pathway for the employer. It's fraught with difficulty to end up, because likely scenario, the person who's in the superior or senior position, whether it's the male or the woman, say it's an executive, the company's not going to want to move the executive, and so then the company's going to look to the subordinate, and it's going to look to, and then it just opens claims of, gender and power and issues. So it's not an easy road. It's not an easy path to assume that you can resolve the situation by we'll just separate the 2.
And let's face it. I mean, the reality in our world is that usually the supervisor, the higher level person, is the man. The lower level person is the woman. And so we have to be very careful, because, again, as Gary says, it's easy to move the lower level person, say, it's an admin or somebody whose position is more flexible, transfers are available, and then there can be an allegation of gender discrimination.
If there hasn't been a complaint and there's just a rumor, how far do I have to go to approve or disapprove?
You don't have to engage in this at all. This is really completely discretionary as far as what makes sense in your workplace.
Unless you have a policy. So I've talked with a lot of employers. When I review this issue, they say, you know what? I don't want to have a policy. I often recommend you should have a policy that would prohibit any personal, sexual, intimate relationship between anyone in a supervisory chain of command. And a lot of employers, clients will say, you know what? I don't want to have that written, because then if you have a written policy and then word comes to your attention that Steve and Amy are in an intimate relationship, then you have to do something. And then what do you do about it? So some employers, and I think legitimately, because it is a very difficult area, say, you know what, we'll deal with it on a case-by-case basis. I don't want to have a policy in writing that's then going to require me as the employer to do something that I may not want to do and no one may want to do, and there may not be any complaints from anyone else. You run the risk, though, that someone down the line, someone's going to complain that Sue got better treatment, got a better raise and a better assignment and better customer list than I did because she's sleeping with the boss, kind of a thing.
So very, very careful. And again, it is completely discretionary. But I can't underscore Gary's point enough that if there is a policy, you must enforce that policy. And that's true for any policy that you have in your handbook or otherwise. You should have policies that you are comfortable and able to enforce consistently across the board all the time.
So what if their peers, they get romantically involved, we have them sign one of these little letters, and the relationship falls apart and one party starts claiming sexual harassment against the other one? What does the employer have to do at that point?
Well, if you want to take the most extreme approach, which is to have them sign this contract that says, "Oh, we release all legal claims," and blah blah blah. The fact is, it may be communicating to these employees that they've released all legal claims, but the law is that you cannot release legal claims that may occur in the future. You can only release any potential legal claim that has arisen up to the time that you sign that release. And so you're still vulnerable to a potential sexual harassment claim. And if it's against a supervisor or manager, you're automatically on the hook. If it's between peers, you're on the hook if you knew or should have known about the sexual harassment. So, it is dangerous to have relationships in the workplace. Do they occur all the time? Do they lead to liability? In most cases, no. But there are certain workplace cultures where you really want to take this very seriously. And just to this point of enforcing what policies you choose to have in place, I had a situation with one of my clients where we had a sales manager who was traveling with a salesperson, and they were both married, but they were having affairs. They always booked 2 rooms, but they always used 1 room, we found out a long time later. Well, turns out we have a policy in the employee handbook that specifically says that the person, I didn't write this particular policy, but it's in the handbook, the person in the higher level position has this requirement to let management know, to let the company know of the existence of this relationship. Obviously, this guy did not do that. Turns out this guy is a shareholder, a C-level executive. Nobody wants to let him go. They want to somehow get rid of the woman, right? Very difficult. But they had no choice but to discipline him purely because he violated their policy. He did something that was against policy, and then he didn't report, which was required by policy. And so they found themselves in a very, very difficult position.
This is the way these things come down. Any other questions on this?
Just quick, you say employees, what about if you have contractors?
Well, as you know, you're required to protect your employees from vendors, contractors, third parties, customers with whom they interact as part of their work. And so potentially you could have the same issues. I did want to talk about upcoming legislation. In particular, I wanted to focus on non-compete legislation. We do have a few more minutes. Many of you have probably seen the news that Governor Patrick has proposed a bill which would ban non-competition agreements in Massachusetts. In fact, there have been 3 bills pending for about 4 or 5 years that to some extent either ban or reduce the scope of legal non-competes in Massachusetts. Right now there are, Evie, is it 18? I think there are 18 states that have either made non-competes completely unenforceable or have proposed legislation to make non-competes completely unenforceable or have in some way reduced the scope of non-competes, the universe of non-competes that can be legally enforced in those states. So there appears to be a trend toward limiting non-competes. In Massachusetts, up until this time, at this time, non-competes are absolutely enforceable. The way the courts look at them is to weigh the interests of the company in protecting their legitimate business interests, their good faith, their goodwill, their relationships, their reputation, their confidential information, against the interests of the employee in pursuing a livelihood, in pursuing their chosen career. And they look at non-competes that way. And typically they'll be enforced if they're reasonable in duration, reasonable in scope, and don't unreasonably burden the employee while reasonably protecting the interests of the company. So that's the way they're enforced in Massachusetts. It's this balancing. There are certain exceptions in Massachusetts for physicians, for social workers, for nurses, and for people in the broadcast industry. I've never quite understood that one.
Right,
and for lawyers. Never lawyers. We always get the goodies because we write the laws.
I've never understood the people, how the
In the
broadcast
broadcast-
industry, how they got
Right,
that in there.
like-
Good lobby.
Exactly. Just DJs can't have non-competes. Right. For example, so what's happening with this proposed legislation and how is it going to affect you? Right now, the governor's proposed legislation is being fast-tracked at the State House, and we expect that it will become law. There's been, over the years, all this work toward limiting or banning non-competes. The important thing to remember is that really the concepts, the principles that we've been talking about, that I've been talking about with my clients all these years, still apply, which is that you always want to protect your business in a way that is with restrictive covenants that are as narrowly tailored as possible to protect your interests without overly burdening or limiting your employees. So non-competes, which say you cannot go out and work, say, in this industry or work with our direct competitors, are fairly broad. They're broad restrictions, and typically we've used them only for situations where we absolutely need them to protect our interests, because we have other tools for protecting our interests, such as confidentiality agreements. If you want to protect your business information, your client's information, your product information, your financial information, you can have a confidentiality or non-disclosure agreement. With salespeople, people who go out and interact with your clients, with your customers, you can have a non-solicitation agreement. They might go to a competitor, but they're not allowed to grab your clients, or they're not allowed to use your vendors. There are other ways, such as trade secret agreements, that you can protect your interests. You could have non-solicitations that prevent somebody, for example, from soliciting your employees and your contractors when they leave. So there's not going to be some kind of a lift out, and they're not going to raid your staff. So I encourage you to be thinking about your non-competes to the extent that you have them in place, and whether there's a more narrowly tailored way to protect exactly what it is you're trying to protect in that situation without having a broad, across-the-board non-compete. And to the extent that you can do that, you're going to be in good shape, because this new non-compete legislation, while banning non-competes, does allow specifically for agreements not to solicit or hire away employees or independent contractors, agreements not to solicit or transact business with customers. It specifically still allows for non-disclosure agreements. It specifically still allows for non-competes in connection with the sale of a business for employees who own at least 10% of the company and receive some significant consideration as part of the purchase of the business. And it still protects and allows you to use no rehire provisions. So if somebody leaves, they have no right to be rehired. They waive their right to be rehired. So I don't know if Gary has anything to add, but my advice at this point is to expect that at some time in the future, your broad non-competes may not be enforceable, and so we want to the extent possible, again, protect our interests with these other tools that we have. Depending on what exactly it is that we're trying to protect, we can use these other tools.
There is some strong opposition to the bill. I mean, it feels like now that the governor is behind it, there's a momentum, there's a groundswell, because there's been bills that have been introduced, there's several of them that have kicked around and gotten nowhere, and this is the first time that the governor has gotten behind it. But the EMCs of Massachusetts, Fidelity, a lot of the big employers have come out strongly against it. So we'll see. I think there's still an expectation that this time this will get through, and as the governor points to, and a lot of people in support of this legislation point to, California has for many years, as we all know, banned non-compete, and it has certainly not slowed the pace of innovation and worker mobility in California.
And in fact, although Associated Industries and a lot of big companies are against it, this is part of an economic growth piece of legislation. So, I mean, it's the governor's view and the view of many that reducing non-competes actually fuels business and fuels the economy because it encourages innovation. You're not shutting people down.
Is there a distinction in the draft legislation which you pay for?
One of the bills that has been pending, the Brownsburger bill, had what's called garden leave, where if you continue to pay the person for that period, you can ask them to sit out or sit in their garden. This particular bill does not include that. I think that's a good point, and I suspect that may evolve as the bill goes through the committee process, that it may be that you can pay somebody to sit out.
California doesn't have that.
California, no non-compete.
California non-compete is a void as against public policy, any non-compete agreement. Not, you protect trade secrets, protect confidential information, but there's no way, shape, or form that any non-compete agreement can be enforced that would be seen valid under California law. And my understanding is that the governance bill is modeled on that. I haven't looked as closely as Tamsin has.
In my experience, oftentimes my clients are having their employees sign non-competes that are unnecessary. Really, non-competes are only necessary in my opinion, in very rare circumstances, because you can have the non-solicitations and the non-disclosures, and you can protect what it is you need to protect in most cases. So I would think carefully about those non-competes. And I've had clients who've come to me and they've had everybody, including their receptionist, sign a non-compete. It's just, obviously overkill.
We've defended a case where another company tried to enforce a non-compete against a receptionist.
Okay.
Didn't get very far. It was a car industry case.
Always tough.
For you car dealers here.
Okay,
it wasn't
we
you
have
guys.
one question from one of our car dealer friends here.
If someone's already working for you, can you ask them to sign an artist solicitation agreement?
Yes, you can. The question is whether there's going to be adequate consideration. Our friend back there, yep. And so it's unclear in the law whether continued employment is adequate consideration for restricted covenants. So we always recommend that there be some kind of remuneration consideration at that time, like they get it when there's a bonus, or they get it for some kind of extra consideration.
There is a trend. There's no definitive, there's no authoritative, what we call authoritative opinion or decision on that issue about whether continued at-will employment is consideration for presenting and signing a non-compete.
So better
but
safe
the trend
than sorry.
is at the Superior Court, the trend is in federal courts and Superior Courts to find that it is, but in the exercise of, lawyers are usually cautious, so we would, we would always advise if you could find some way to give something extra, whether it's a bonus, raise, promotion, whatever it is, give something extra and tie it to that obligation, then you take away the issue.
Okay, please stay and ask us any individual questions you have. Enjoy the rest of your breakfast or start your day. Thank you so much for joining us.
Thanks
It was really a
for
pleasure
coming.
having you.
Thank you.